Hi everyone, welcome back to our video updates. It's Sade. Today's video is going to be a quick video to cover a question that we received regarding different types of liens. Again, we get a lot of questions about liens that show up in the records whenever somebody is trying to claim excess proceeds. But this is going to also apply just in general. Let's say somebody is selling a house and the title search comes back saying that there are liens inside the chain of title, which is just saying that there are liens that were recorded against that property. But sometimes the lien is actually against the person and it attaches itself to that person's property. But the title companies will still come back with a question mark because they want everything to be clear. They don't want any issues for the person purchasing the property from the seller. So in this case, the lien would show up against the seller's name inside the property records, and it attaches to the properties that the person has in that particular county. So how does that even occur in the first place? Typically, it's because there was an individual or company that received a judgment against that seller in the past, and that company or person went ahead and obtained what we call an abstract of judgment, which is just a summary of the judgment itself. And that document is then recorded into the property records in that county. Even if I don't have property yet and somebody got a judgment against me, they can actually preemptively file something into the property records ahead of time. So anytime I have a property in that county, that document is now a lien that attaches itself to my property. And so the way that the courts and the legal world in general would determine whether the lien would have any effect in future is to figure out whether that lien was perfected. So the liens of HOAs typically would be perfected because they have additional documents called the CCRs, the covenants, conditions, and restrictions documents that contain all of the rules and laws of that homeowners association. And typically they give themselves priority regardless of whether they actually file the physical document on time or not. And with HOAs, they don't even have to get a judgment from a court in order to have their liens actually be recognized. So their liens are typically automatic as long as they can back it up with their account statements, and they would file it into the property record. So that's one type of a lien. And then the other common types of liens would be the judgment creditors liens. Like I said, maybe a credit card company or maybe a hospital bill. So the medical bills will also attach, but those other ones have to get a judgment first and then convert that judgment into an abstract of judgment and file it into the records. So how do they then perfect or not perfect, right? So we call it perfected if it's done properly and filed prior to the incident that triggers payment. So that means that if the judgment creditor received a judgment in 2010 and I happen to get my property in 2015, then that judgment creditor, if they already recorded the abstract of judgment into that county's records, then their lien was already there ahead of me purchasing the property. So it will attach to the property that I purchased. But let's say that I purchased the property in 2015, that judgment creditor had a lien in 2010, and then never recorded any abstract of judgment against me. Not perfect. So perfection has to do with the timing of the filing. But let's say that the same judgment creditor received a judgment against me in 2010, recorded the abstract of judgment around the same time in 2010, and then I purchased property in 2015, and I am now trying to sell my property in 2021. So now they've had their judgment and the abstract of judgment for about 11 years. And I'm now trying to sell my property. So the title company will do the research and they'll see that lien and say, well, we think this one has to be cleared up before you are allowed to sell the property because the buyer has to have a clear record, clear title. And so they would ask me to make the payment, and most people will go ahead and make the payments. But the truth is that even though that lien was perfected against me, there might still be an exception to the rule that allows me to bypass the lien altogether. So it depends on what kind of arguments your lawyers can make. It depends on the laws in each state. Here in Texas, the judgments are good for 10 years and they must be renewed every 10 years in order for them to be effective. So there's a small window of time where the creditor is allowed to go back and quickly catch that they forgot to refile the judgment or renew the judgment. Then they can still go ahead and renew it. It doesn't automatically go away, but 10 years is the standard. And then if they don't renew it after 10 years, then it's arguably not attached to the property anymore. So a good lawyer will be able to argue that it's already expired, that they don't have to pay that lien to the creditor. So the seller would not have to pay that lien in that instance, as long as the title company is satisfied. So in the context of the excess proceeds world, it's just a different type of sale. It's still a sale. It's just that the sale is a forced sale instead of a private sale. So the government is either going to force sale of that property because I didn't pay my property taxes, or the mortgage lender is going to force sale of that property because I didn't pay my mortgage payments, or the HOA might force a sale because I didn't pay my assessment on the home. So in any scenario, the end result is a sale. And the only difference in those forced sales is that there is no title company to determine whether the chain of title is clear or not. However, if there is money left over after the sale, there is a priority or hierarchy of parties that are entitled to the money. And one of those people would be the previous owner. So let's say my property was sold at foreclosure sale and there was money left over after the amounts owed were satisfied, then I should be able to step in and claim those funds. So that's what we're talking about in this part of the video. If I step forward to try to claim the funds and the other party, whether it's the HOA or whether it's the mortgage lender or whether it's the county's tax office, their lawyers, if they see that there's a lien out there, sometimes they refuse to pay me because they think they have to satisfy that lien holder first. So that's another scenario in which the liens will come into play, and they would then get a chance to claim the excess proceeds ahead of me in most states. So that's the way it typically works, that the hierarchy of priority is that the lien holders will get paid first, and then the previous owner will get paid whatever is left, if there's anything left. And of course, when that kind of thing pops up, most people will go ahead and just try to pay it and negotiate it and all that. But we first check to make sure that the lien was perfected. So meaning that, was it actually filed into the record before the sale occurred, A, and B, was it the type of lien that hadn't expired yet? Because some of them have already expired because they've been filed so long ago. So there are two different ways that you look at it. Was it perfected in the first place? And if it was perfected, was it perfected so long ago that it should no longer attach to the property at the time of sale? So those are the questions that your lawyer would consider if the lawyer knows about these types of things. And a lot of lawyers should know about these types of things. So they'll be able to argue and sometimes get rid of those liens so that you as the asset locator, or you as the claimant, if you're the previous property owner or the heir to the previous property owner, you could still get all of the money left over from the sale, which will be all of the excess proceeds. So that is my quick video for you today. I hope it's clear and not confusing. So yes, the liens could come to play to affect somebody when they're trying to sell property, or when they've gone through a forced sale, whether they're the previous owner or the heirs of the previous owners. But you could still avoid them sometimes, depending on whether you could attack the way that the lien was filed, or that there was a defect in the filing itself, or in the timing of the filing. So perfection has to do with the timing of the filing. And then the other thing you could do is attack it based on expiration. Maybe there's a statute in your state that says that all of those judgments expire after X amount of years. Of course, if it's an IRS lien, theirs don't expire. If it's a child support lien, it's not going to expire either, because it's a special type of lien. They want the children to be taken care of. So those survive even death. So let's say I was ordered to pay child support to an ex, and I didn't pay the child support for years, and now I'm dead, no longer alive. My heirs still have to pay that child support if they inherit my property. So that child support lien would continue to attach. I know people don't really believe that stuff, but it's the truth. So I just thought I'll give you this quick video so that you can start thinking along those lines when you see things that look scary. It doesn't mean that they will have any effect on your sale of your property or on the excess proceeds from the sale of the property. I hope this has been helpful to you. And as always, if you like what you've seen, make sure to click the like button. It helps me to continue to make more videos. And if you like our channel, remember to subscribe so that you don't miss notifications for new videos. And I hope you stay safe out there, and I'll talk to you next time.